Anybody? I'll bring it back to council.
So my understanding is that with the attorneys, it's not that they think that it's going to go over 20,000. It's that if we, I have a question, Sandra, if we retain them, we aren't going to be the ones that say, okay, it's too much money now, it'll stop. The actual judge has to let them go, correct? Is that what it?
What happens is they cannot withdraw from the case without leave from the court. Is that correct?
Typically in litigation, an attorney is obligated to continue representing his or her client until the court gives them leave to withdraw. Assuming that we're not directly on the eve of trial or something along those lines, a court normally will grant leave to an attorney to withdraw if the attorney's client has stopped paying. So a good excuse for withdrawal is my client won't pay me anymore, unless you're trying to make that withdrawal the day before trial or something along those lines where the client would be adversely affected to a very great degree. So the answer to your question is yes.
And did this firm actually say that they weren't able to give an accounting, or they just couldn't guarantee that?
They could not agree to a hard cap because it puts them at risk for any overage. If the court were not to allow them to withdraw, they have to keep representing the city because they actually are going to a litigation. And this only applies, the issue, that was mentioned by another citizen was about the $500 cost for the smaller cases. Those cases do not involve litigation. The only case that's going to involve litigation is a big case like, for example, this case. And the court does have to approve the fees. So they cannot charge fees that are unreasonable because the court would not approve them, because the person who's being foreclosed upon can protest it. So,
does the court review the fees periodically, or is it just at the end they review it and say, oh wait, no, this is too much?
And if, for example, if they tried to charge $30,000 and the court only felt that $20,000 was appropriate, they wouldn't get it anything other than $20,000. They don't just get fees, monthly or something like that. Is that correct? They would get them at the end?
Essentially, at the time that the judgment is being entered, the attorneys would submit their fees to the court to be included in the amount of the lien. The court would go through it, and conceivably the person being foreclosed upon could object to either the amount of time that was spent or particular entries if the person thought that those were inappropriate. And the court will make a decision about whether or not to permit or not permit those fees that are objected to. Unless somebody objects, the court usually just passes the fees along.
But there is some protection in there.
There is an opportunity to object that the fees are unreasonable at that time. So I think the finance director's perspective is that since the property owner has the ability to object to excess fees as a part of the process, and those fees are not then directly borne by the city, they're actually recovered by the city through the foreclosure process. So there's a little bit of a check and balance there, I think is what you're being told.
That's what I'm being told, yes.
So to clarify what Mr. Besnay said, we assume we've checked with numerous attorney firms.
No,
you haven't?
I do not know numerous attorney firms that do this type of lawsuit. I'm sure that just about any attorney can do any type of lawsuit. It's like a specialty. In times like this, a lot of attorneys try to take on, they expand to different fields. So there may be other ones that may be willing to do it, but I know the reputation of this firm, and that's why I'm recommending that particular firm. Have worked with them for 20 years, and all the cities around here that I've talked to have recommended this particular firm. And also because they have the ability, they have researched this very thoroughly to work with the banks. One of the biggest problems, as I think Councilman Caramello said, was with all these foreclosures, it's hard to get a hold of a banker. They have a way of, they've developed contacts with the right banker to persuade them, and especially in the smaller cases, to pay up. Because other that, if they don't, then they will have to file a judicial foreclosure action. So they're able to collect more money. They're almost a little bit like a collection agency. That's why I like the firm also, is because they were able to do more than just file a lawsuit. They had developed the expertise to do this sort of thing.
Ms. Sato, in your experience, not here in Dixon, but in other cities that you've worked with as a finance director, have you had experience with this particular firm in the past?
20 years.
I'm sorry?
20 years of experience, and actually have worked with them in cases where the whole assessment district was bankrupt for years, and we had repeated sales with them, and they've always come through, and the fees have always been reasonable. I've never seen anything more than $20,000, but it's just that they don't want to agree to a hard cap.
And have you worked with other firms other than Sherman Phillips?
I don't know another one that has experience with that. I do know that there are firms that will, have branched out with the economy being like it is. Different firms take on different things. I don't know of one, but I would never hire an attorney based on the fee. Obviously, it's based on the experience they have, and just like any other position. And it's not the same thing like our city attorney where we get billed for, he's not doing litigation for us. This case is where you would be involved in litigation and have to obtain leave from the court. At least that's what I've been hearing told.
Okay. And in discussions with other cities, are those cities within Solano County?
And other counties that I have worked in.
And their experience has been similar to what you've just described?
Yes.
Thank you.
Mr. Mayor, I did want to mention that I have had experience with the firm as well, over a period of several decades also. And although I have always acted in the capacity of city attorney, both in-house and in private practice, Sherman & Feller is actually the only firm that I've utilized for these purposes over probably 25 years. For much the same reason that your finance director is stating that, and she came up with the firm independently of me. But if one were to ask around, that's going to be the firm that you're going to be referred to.